28 years ago this week, I was one of the people who found Jennifer Lewis's burning body in the schoolyard of Jefferson Elementary School in Davenport, Iowa. When I walked across that field toward what I thought at the time would be a minor fire, I had no idea what I would see would be affecting my life nearly 3 decades later. Stanley Liggins, who stands accused of raping and strangling Jennifer before dumping her body, dousing it with gasoline, and setting it on fire, is being tried a 3rd time for her murder. In 1993 and 1995, Iowa juries convicted him, and both of those convictions were overturned by appellate courts. For the past 3.5 weeks, jurors in Waterloo, Iowa heard evidence in a 3rd trial. Wednesday morning, lawyers presented impassioned closing arguments. Stanley Liggins' fate now rests in the hands of 12 jurors. Deliberations began Wednesday afternoon, and we await their verdict. Suspect Convictions has been downloaded millions of times by listeners throughout the world and risen to number 2 on the iTunes overall chart. If you have been listening to our first season and our current season, you know more about this case than any of the jurors now pondering Stanley Liggins' fate. So in a break from our usual format, we are leading the episode with a discussion of the trial and then providing the closing arguments and rebuttal in their entirety. You'll likely hear from us next when a verdict is reached.
I'm Benjamin Payne, reporter with WVIK News. Joining me now is reporter Scott Reeder, who is in Waterloo, Iowa, covering the murder retrial of Stanley Liggins. This is the 3rd trial of Liggins ever since the remains of 9-year-old Jennifer Lewis were found near a school in Davenport in 1990. Liggins had been convicted twice for Lewis's murder, but both of those convictions were eventually overturned. Now we are nearing the end of trial number 3. On Wednesday, closing arguments were made, and the jury left the courtroom to begin deliberations. Scott, thank you for joining me.
It's wonderful to be here.
So before we get to the closing arguments, let's just talk a bit about the jury, because earlier this week there was sort of a twist. 2 of the jurors were absent from the courtroom on Tuesday. 2 African-American jurors, which is significant since Stanley Liggins is African-American, Jennifer Lewis is white, and this case has had racial undertones pretty much since day one. So on Tuesday, Judge Marlita Grieve would not say what happened with them. Do we know any more now that Wednesday's proceedings are over?
No, she says she can't tell me anything until after the trial's over. But we do know there's one African American on the jury, and we do know there's one person who put on this questionnaire. He labels himself as other under race. So I don't know what that equates to. Probably somebody of mixed race. So they're still, unlike the first 2 juries and the first 2 trials, this is not an all-white jury.
And so closing arguments were made on Wednesday. How did the prosecution sum up their case?
Well, the closing argument was made by Julie Walton, who's the sister of Scott County Attorney Mike Walton, and she did a superb job. She methodically went through all of the evidence presented over a little over 3 weeks and just laid out detail after detail after detail after detail why this leads to jurors to believe that he is guilty. And, I thought she did a really admirable job. In fact, I made a point when I saw her in the hallway, hey, you did a really good job on that, Julie. I mean, I don't give empty flattery. If somebody does just an average job, I don't say something. But I thought she did a very good job doing that. I think she is an extraordinarily detail-oriented person, and you could see the jurors were in rapt attention throughout her presentation. And it went on for about an hour and a half.
And how about the defense attorneys for Stanley Liggins? How did they close their argument?
Well, that would be Aaron Haubacher. And, Aaron was one of a top collegiate debater when he was attending the University of Northern Iowa. His oratory is superb. I thought that he did a good job presenting. There were some things that I wondered why he didn't hit on harder. There were some things that he focused in on that kind of made me scratch my head. But his delivery style was more impassioned, I would say. Julie's was more methodical. And so, yeah, I saw Aaron out in the hallway as well. And I said, hey, you did a nice job with that. I mean, so, yeah.
And is Aaron a public defender?
He is a public defender. He's the head public defender for this region of Iowa. And he's headquartered here in the Waterloo, Cedar Falls area. And, of course, after the defense gives their closing argument, then the prosecution, because they have the burden of proof, makes a rebuttal to the defense's argument. And the rebuttal, of course, was given by Mike Walton, the Scott County attorney, who heads the office up, and he did a good job as well. I was very impressed throughout this trial. All of the attorneys involved struck me as really good at their craft. They understood the issues well. There wasn't what struck me as a disparity in the caliber of attorneys between the two sides. I thought both sides did a good job. But when Mike presented, he tried to address each one of the issues that the defense raised. You know, one of them was this idea that there's this band of dog thieves on the west end of Rock Island who stole Jennifer's dog about a month before she died, and had some kind of confrontation with the family. And, you know, and Aaron Habacher, the defense attorney, had tried to make a lot of that, saying, well, why didn't the police look into this? Why they stole this girl's dog, and then her stepfather stole it back. Why weren't they looking at these people? So it's kind of, his strategy was, you know, diverting the jury's attention to as many different people as you can and making the case for how it could be anybody but Stanley Liggins. And so that was interesting. There's a bunch of things I'd like to touch base with you on. For our listeners, I'd like to point out that we're going to do something exceptional for this podcast. We are going to present the closing arguments and rebuttal in their entirety, because I think the oratory on skills of all three attorneys was just excellent. And if you've been listening to this podcast for a period, you're going to want to listen to how the attorneys address these issues to the jurors. This is their last chance to speak before a verdict. So I think this is going to be a really good thing. But here's something that really struck me, Ben. During all three trials of Stanley Liggins, the defense never tried to present an alibi defense. You know, they never said, hey, Stanley couldn't have done this because he was someplace else. They never said, had witnesses come forward and say, hey, I was with Stanley at the time this crime happened. This has never happened. And I find that curious. I mean, why hasn't it happened? Could it be because he was there when the crime was committed? I don't know. But I found that very curious, that there's never been an effort made to make the case for why he couldn't have done it because he wasn't there or whatever. I mean, I think that's really stood out to me as an absence of a defense.
Has that alibi defense been made in either of Liggins' previous trials?
Never has happened in any of his trials, as I said. So I think that's curious. I mean, what one would expect if you were saying, hey, I didn't do it, Or if somebody accused you of doing something horrible at 8 o'clock at night yesterday, Ben, what would your response be? Hey, I couldn't have done that because I was out to dinner with my girlfriend, or I was at a bar with some friends, or I was doing XYZ. Or even if it was like, no, I was home taking a nap, you could at least make that argument, or you could bring that up. But he's never brought up that he was doing something else. I find that very curious. The other thing that struck me as a little bit, I don't want to use the word disingenuous, but I think I can use that word. The defense made the case for there was a rush to judgment to focus immediately on Stanley within 2 days of the trial, or excuse me, of 2 days of the murder. There was a rush to judgment for the police to just focus in on Stanley when, gosh, there were a lot of other people they should have been looking at. And they made a case for, but why did they look at him? Why didn't they look at other people? Why Stanley? Yeah, I'm not faulting the defense for doing this, but it's a little bit disingenuous. The two reasons why they focused in on Stanley are things that are inadmissible in a court of law. First reason they focused in on him, because he was a friend of the family who had been there that night, and he was out on bond for sexually abusing another 9-year-old girl. So wouldn't it be pretty natural if you're a police officer? Hey, let's look at this guy. This is this child. Jennifer was raped and strangled and set on fire in a school playground. There's a sexual element to this. And this guy who was repeatedly over at the Jennifer's home that day is out on bond for sexually abusing a different girl in Rock Island. And he, of course, later convicted of that crime. So that's one reason why the police immediately started focusing in on him. But here's the
And we should just note for listeners that point of Liggins being convicted for sexual abuse a month before the killing of Jennifer Lewis, that's not been revealed to jurors.
Jurors are unaware of that. That is something that's being kept from them. And so the defense was able to use that to their advantage. I mean, there's like, well, they can't say why they focused in on him, so we're going to make it look like, hey, it's because they just focused in on him for no reason, because they can't explain the reason that they focused in on him. The other reason they focused in on him is because they took the primary suspect, Joe Glenn, and his wife, and they put her through polygraph tests, and they passed. And then they put Stanley Liggins through a polygraph test at the Davenport Police Department, and he failed. Of course, polygraph tests also are inadmissible in court. But those two reasons are why they focused in on Stanley so early on in this case. So, yeah, Aaron Habacher gave a very good closing argument. I think his oratory skills are very good, but I think he used to his advantage that the prosecutors can't be wholly forthcoming under judicial rules for why they focused in on Stanley so quickly. But on the other hand, County Attorney Mike Walton focused in on the testimony of Dave Holden, who was a detective, sergeant at the time. He was actually a good friend of mine at the time, back in those days. He's passed on a few years ago, but the prosecutor hit it on there and said, what do you think? The Dave wasn't telling the truth here, and they read his testimony in or whatever. And so when the listeners listen to the arguments, the rebuttal, listen closely to that, because I kind of had a pause on this, because you'll remember when Stanley Liggins was initially arrested, it wasn't for the murder of Jennifer Lewis. Stanley Liggins was purportedly involved in drug trade in the Quad Cities. According to testimony in the first trial, he was providing cocaine to Jennifer's parents for them to resell in Rock Island. When the police questioned him in an interrogation room in Davenport Police Department's station, We don't know exactly what was said because, for whatever reason, the recording equipment was not functioning at that time. But we do know that at the end of everything, Stanley signed a waiver allowing the police to search his home, search his hotel room. Now, he insists to this day that the police had said to him they were only interested in evidence involving Jennifer Lewis. They weren't interested in any other activities he might have been involved in. But as soon as they searched the room, they found some drug paraphernalia, a grinder that was used to break rock cocaine down into powder form. And they found some residual cocaine there. And they found a stun gun. And they found some other things. And they arrested him. And what's fascinating to me about this is, of course, they charged him in Illinois for the drug case because that's where they found the cocaine. But that eventually, when Dave Holden testified in court in Rock Island, Illinois, about the search, the judge didn't find him credible and threw out the search, and which essentially just threw out the whole drug case. Of course, he also by that point had been charged with the murder of Jennifer Lewis on the Iowa side of the river. Interestingly enough, the Iowa judge, looking at the same evidence that the Illinois judge did, said no, it was a legal search and allowed all that evidence in. So the reason I find that curious is Mike Walton was extolling the virtues of this detective and saying, what are they trying to say, that he was perjuring himself? Well, you had none other than a Illinois judge involved with this case essentially say he didn't believe Dave Holden. Now you have an Iowa judge that says he believes him. So I found that curious as well, because this isn't the first time questions have been raised about Dave Holden's testimony. And this is one of the things that really struck me as strange, that neither one brought up in closing arguments. Joe Glenn got into an argument in about 1999, about 9 years after Jennifer was murdered, with his neighbors in Moline, Illinois. And he was very drunk by all accounts, and he was yelling at his neighbor, Arnold Pappas. And two witnesses, Arnold Pappas and another neighbor, said they heard him say something to the effect of, I killed Jennifer, and I'm not afraid to do the same thing to you. To me, that's an absolutely bizarre thing to say, even if you are extremely drunk. What kind of parent would say something like that to intimidate a neighbor? I know that at least one juror gasped when she heard that testimony the first time in this trial. Mike Walton didn't try to address that at all. He's an idiot. He says stupid things when he's drunk. That was never brought up during the rebuttal. But the defense attorneys never really did much with it either in their closing argument, which I thought was interesting. I mean, to me, that seemed to be a natural place to go. Now, Mike did an excellent job as a prosecutor showing documentation on where the stepfather, Joseph Ace Glenn, was the night of the murder, and who the witnesses were, who saw him where, who saw him when, and kind of laying out the case for why he couldn't have done this crime. And he also was very honest. Hey, he was our initial suspect, but we could not find any evidence that he was involved with this. And the timeline just doesn't work for him to have been involved in this. So I thought that was interesting. The one that really struck me as bizarre is, Wanda Hughes, the woman who looked out her window and saw taillights a block, 2 blocks away from the house she was in, came forward weeks later after Stanley's arrest and said she would recognize those taillights on a car that she saw near the fire. And she became the star witness in the first 2 trials and a significant witness in this trial. But The reason we're having this third trial is it was withheld from the defense. I should say an appellate court found that it was withheld from the defense that she had been a paid police informant in 87 other cases. And Davenport police insist we didn't know. The detectives working this case did not know she was a informant for other police officers within the department and was getting paid by them. If I had been the defense attorney in this case, I would have walked right up to the jury box and said, "Hey, what are the odds that the woman who just happened to look out her window at the exact time that there was a car parked over there by this fire a block away and just happened to memorize the taillights, just also happened to be somebody already on the police payroll assisting them with other cases?" I mean, I think you could make a pretty compelling case raising doubt in this. But that didn't really happen. They didn't really push that issue much. I mean, they pushed other credibility issues involving Wanda Hughes, but I invite the listeners to focus in on that when Aaron Habacher is giving his closing arguments on tonight's episode. But I'm just kept wondering, well, why aren't they making more of this? The other one that struck me as really interesting here is this Frank Rising. He was the cellmate for Stanley Liggins. Supposedly the two are stuck in the same cell for weeks on end and they aren't even speaking to each other. And then suddenly something comes on the news, on the TV in their cell. It shows Stanley Liggins' case. And he says, "Hey," Frank supposedly says, "Hey, that's you." And Stanley supposedly says, "Yeah, I may have done it, but they'll never get me for it." As you know, I went out to Sioux City, Iowa to interview Frank tail end of 2016. And he weaved a whole different story. I mean, without any prompting from me, that, gosh, the prosecutors, the police hauled him into the detective bureau and threw pictures of a burned child in front of him and said, "If you don't testify against Stanley Liggins, we're going to charge you as accessory to murder after the fact. And you don't want that." And this is the story he tells. I don't know if he's telling the truth or not, but what I do know is he told me on tape an entirely different story than what he testified under oath in the courtroom. So either he was lying then or he's lying at one point. He's either lying in the courtroom or he's lying to me. But to me, I think the defense could have done a much better job of showing the disparity between what he publicly said to the millions of listeners of Suspect Convictions and what he said in that courtroom. And that didn't really happen. I thought that was curious. And I'd love to talk to the defense, kind of ask them in more depth once the jury comes back with a verdict. Why didn't you do this? That struck me as something that, would have cast a pretty strong doubt, especially when you have on tape him weaving an entirely different story than what he did in the courtroom. Right now, where we're at, Ben, is the closing arguments have been made. It's gone to the jury. The jurors deliberated for about 3 hours today. Then today being Wednesday, and they're going to be back and start deliberating Thursday. Our listeners should keep their eyes out for what comes on their feeds for this case, because obviously not much is going to happen while there's deliberations going on. But we're going to do a very thorough job of reporting the verdict, but also talking to the variety of cast of characters involved in this case and getting their thoughts. Not just the lawyers, but we're going to be talking to some of the, at least one past victim of Stanley Liggins. We're going to talk to other people who were this crime has been touched. We're hoping to talk to Stanley Liggins himself. I mean, I don't know if he'll be able to talk or not, but obviously, but we're hoping to talk to as many people as we possibly can in this case and give you the best trial coverage possible.
Now, in Liggins' past two trials, how long did it take the juries to reach a verdict?
Well, you're really putting me on the spot, Ben. If I remember right, the first trial, I think it was less than a day of deliberation. I think they deliberated late into the evening and then came back the next morning, and they had a verdict. With the second trial, I want to say it took them 2.5 days. Of course, there's more challenges in this case because an awful lot of the witnesses have died or are in poor health and couldn't testify. So they had to have their testimony from previous trials read into the record. And that makes it more challenging if you're a juror to evaluate their testimony. Well, you can't listen to you can listen to what they said, but you can't listen to how they said it. You can't listen to the inflections in their voice. You can't watch to see if they looked over to one of the either the defense or the prosecution table to see if they can get a cue from a lawyer. There's a lot of things that are lost in there. Plus, when people are reading somebody else's words, it can get really boring really quick, and it's easy to zone out what's being said.
All right, that's reporter Scott Reeder. He's covering the third trial of Stanley Liggins, who is being charged with murder of Jennifer Lewis. She was a 9-year-old girl from Rock Island whose burned remains were found in Davenport 28 years ago in September of 1990. The jury entered deliberations today. Scott, thanks for joining me.
Thank you. Prosecutor Julie Walton was the first person to address the jury Wednesday morning.
Before I begin my closing, I want to thank you on behalf of the people of the state of Iowa for your time and attention, the work that you've done so far in coming to the courthouse and listening to the evidence, and the work that you will do in your deliberations and coming to your verdict. I've thanked many juries. I've meant every thank you sincerely, but in this case, I really, really mean it sincerely because you have, like few juries, spent weeks in this case. Devoting time, sacrificing time. Your employers, your families, your friends have also sacrificed too. But I think you know how important this case is. And I know that you take your job seriously. Members of the jury, in these past weeks, you've heard the evidence from the state. You've heard evidence from the defense. I submit to you that when you review the evidence and you apply the law as instructed, you will reach the only true verdict, and that is that Stanley Liggins is guilty of the murder of Jennifer Lewis. What I want to do now is to review the evidence and the law to show you how we have proven that the defendant is guilty. I think it's helpful as we begin to review the evidence that we follow the path of Jennifer Lewis. We know that that path was brutally cut short, and the end of that path was discovered near Jefferson School at Jefferson Park in Davenport. But let's begin with the first steps that we know, that we heard about with regard to Jennifer Lewis. We heard about Jennifer Lewis and her neighborhood here in Rock Island. We know that her home was on 7th Avenue, right there in the middle of the block, near 11th Street, between 11th Street and 12th Street in Rock Island. Now, we first hear about Jennifer the day before her death. We hear about Jennifer and her actions on Sunday, the 16th of September of 1990, because we heard the testimony of Mark Titus. Now remember, Mark Titus was presented via transcript. And again, you did hear from a lot of transcripts. And we explained that in jury selection. And we explained that you are to consider those transcripts as if those witnesses appeared on the stand. Those transcripts, what was read to you, is evidence just as live witness testimony was. Mark Titus told you of Jennifer Lewis, a helpful little girl who showed up at their house on 12th Street, the Titus residence on 12th Street, on Sunday, September 16th, trying to get some laundry, looking for a blanket. Then she returns home. We also hear about Jennifer Lewis through Brenda Adams, who also told us that the day before Jennifer Lewis's death, that Brenda Adams went to the Glenn household on 7th Avenue. She was there with her daughter, Sky, and Stanley Liggins, who drove to the Glenn residence, who parked in the driveway, who went in the home, who left Brenda and Sky in the Peugeot that they rode in. And Jennifer Lewis, the friendly little girl, came out and talked to Brenda and Sky. And that was the day before Jennifer's death. So we know already that Jennifer is not only outgoing, friendly, helpful, but also very aware of the Peugeot and aware of Stanley Liggins as a person associated with her home, with her parents. Now we're going to move to September 17th of 1990. And before we review the evidence with regard to September 17th, 1990 and thereafter, I think it's important right now, as we consider the evidence, that we review firm numbers that you have heard in this case. The high temperature on September 17th of 1990 was 70 degrees. The low temperature was 46 degrees. The average temperature was 56 degrees. We remember that from the testimony of Professor Alan Zarnetsky, who told us that's what's documented, that's what's official. We also know of landline numbers that important people in this case had. I'm going to review now. This was also in the defendant's exhibit N. I think everyone well knows about landline numbers. That's the one that's connected to the wall that you have to be actually in the place to get the phone call. The Glenn's residence is area code 309-794-1534. The residence of Margaret and Pete Liggins, those are siblings of the defendant, and Sheila Nimmers, who is a paramour of Pete Liggins, is 319-386-2830. The phone number of the Hillside Inn is 309-788-0612. The phone number of Brenda Adams is 309-787-2384. And the phone number of the Titus residence, Mark Titus, is 309-786-3803. These phone numbers are all documented in the evidence for you. Now, the important thing about the phone numbers and the telephone records is, again, they tell us where people are in place because they have to be on that landline at certain times. We do have documented times on September 17th, 1990. Now, members of the jury, we talked again in jury selection about this case occurring 28 years ago. 28 years ago, this very week. And witnesses have testified, and some witnesses had trouble remembering times of day. That's understandable. That's why it's important that we have documented times based on evidence that has been submitted, so that we can lock certain times in, and then we know the sequence of events that witnesses testify to. At 5:24 p.m., based on the phone records, we know that there was a call from the Glens residents to time and temperature. In fact, that's the first phone call we see that day from the Glen residents, is to time and temperature. We heard Sherry testify that they didn't have clocks at the house at that time. So this is how they figured out the time. Again, they couldn't just pick up the cell phone and figure that out. They had to call time and temperature to get the right time. At 7:14 p.m., a phone call from the Glens to Mark Titus is documented in their record. At 7:38 p.m., a phone call from the Hillside Hotel to the Glens is documented. At 8:16 p.m., Christina Olson sees a fire at Jefferson Park. Now, she was firm on that. She looked at the clock. She told you 8:16 p.m. Fire at Jefferson Park. At 8:40 is a phone call from the Hillside to the Glens. At 8:41 is a phone call from the Hillside to Brenda Adams. At 8:54 p.m., Bruce Johnston of the Rock Island Police Department is dispatched to the Glen residence. At 9:06 p.m. is when the 911 call was received by Davenport Police Dispatch regarding what was believed to be a trash fire at Jefferson School. So those are the documented times I want you to consider as we review the evidence in this case. So let's go back and the evidence with regard to September 17th of 1990. And that's what we're reviewing now, is events occurring on September 17th, 1990. Again, we're looking at the Glen residence. You're also looking at Exhibit 4, which is the Glen neighborhood. We know that in the early morning hours, it was a Monday, in regular morning hours, I guess 8-ish, was when Jennifer was taken to school at Earl Hansen School. It appeared to be just a regular day for Jennifer. And so, being a girl almost 10, she goes to school and is working on her school book. Little did she know, as you look at State's Exhibit 82, little did Jennifer know that within hours, the fingerprints she left on school papers would be used to identify her lifeless body in a morgue. So she's at school. You heard both Sherry and Joe talk about other events in the morning and early afternoon hours of September 17th. They had an appointment for their newborn baby, Damien. Then Joe had an appointment at the PO. Then the sequence of events would be that at approximately 3 o'clock, they pick up Jennifer from school. Then they go to Maidright in Moline, Illinois, where they order food. And we heard that that meal took longer than they expected because Jennifer didn't like what she had to eat. We remember that both Jennifer and Shirley Richardson Clark testified that due to what the delay at Maidright, the 4 p.m. appointment for hair for Sherry, getting her hair done by Shirley, that appointment was missed. So now we're into past 4 p.m. And the Glens are still eating at the Maybright, and we heard Sherry say that they went to Goddard's Furniture to look for a table across the street. So we are now, then they return home. Sherry told you that it takes about 20 minutes to get from Goddard's, that area Moline, to the Glen residence. So that puts us sometime after 5 p.m. that the Glens return home. And we can think about that phone call that was placed at 5:24, time and temp. Maybe they were trying to see what time they landed at home. We know from the testimony of Fred Gonzalez that he put them landing back home sometime after 5. So that's, the Glens are back home at their residence sometime after 5, between 5, perhaps 5:30. We know it's after 5:24. Right? We know they're there by 5:24. So the Glens arrive home, and the testimony was that when the Glens got home, Fred Gonzalez was in the backyard working on cars, fixing cars as he does. He had his nephew with him. Nate Roden was also there. Nate Roden had his son with him. Remember the testimony of how Jennifer helped Fred Gonzalez get some water for the car he was working on. He described her as a sweet little girl, helpful little girl, helped him get that water. And we know that at some point after the Glens got home, approximately 6 o'clock or so, Stanley Liggins comes to the Glen home in his Peugeot and parks in the driveway, about right where that white car there in States Exhibit 61 that you're looking now parked. Remember that it was at this time, as Stanley Liggins had arrived, Fred Gonzalez was still there, Mr. Roden was still there. It was about this time, after Stanley Liggins arrived, that Nate Roden said he had a meeting in the yard with Stanley Liggins, and they had arranged to meet again the next day at the Glen residence at about noon. Sherry confirms that she saw Stanley and Mr. Roden talking about meeting the next, well, talking. She obviously didn't know what their meeting was about, but we know based on Nate Roden that they were talking about meeting again the next day at the Glen residence at about noon. Now, we know that the Glens, based on what had happened with regard to Damien, that he was a child who had some serious conditions as a newborn, that he didn't get out of the hospital until September 9th. He was in the hospital about a month after his birth. But the Glens had not really been around this neighborhood for a while because of especially what was going on with Damien, and I think we heard that they were working on the house. Things were going on at the house. So Jennifer really hadn't been hanging out with her friends that much. She was probably, no doubt, excited to see her friends. And recall that at some point after they returned home, this was when Jennifer takes off on her prized possession, on her bike, to go meet with friends. And we know the friend is Samuel. He lives in the neighborhood, not far away. And so Jennifer leaves on her bike and goes to play with her friends. Now, we also heard that shortly after Jennifer left to go play, Stanley Liggins announces that he had people to see, places to go, and he left in his Peugeot to do that. What next happens is that the Peugeot is seen interacting with Jennifer, not far from her house. You heard the testimony of Diane Pemberton. Diane Pemberton lives on 6th Avenue, 1 block north of the Glens, on 6th Avenue between 11th Street and 12th Street. I believe she's at 1129 6th Avenue. Diane Pemberton describes that she saw that Peugeot come down 12th Street, take a left, driving slowly, slows down and stops in front of her house at 1129 6th Avenue and talks with Jennifer. This interaction is seen as well by Mary Ann Allen Watson. That was the first day that she had met Jennifer, remember, and remarks and identified Jennifer by her smile. Outgoing little girl. Mary Ann Allen Watson also saw Jennifer interacting with Stanley Liggins. And then you also know that another woman, Beverly Hall, who talked to Officer Ott during his canvass, she also identified the Peugeot and gave a partial license plate number that matched the Peugeot. So you have those three women who noted this interaction between Jennifer and the Peugeot. And in Diane Pemberton's case, she saw not just the Peugeot, but she saw Stanley Liggins. And she picked him out of the lineup as the second person in, Stanley Liggins, signed her name to the lineup, and identified that this person and this car was interacting with Jennifer Lewis. In fact, she even said that he brought her over, that he directed her over. Remember that? Now, in and of itself, a man interacting with a little girl on the street, nobody's saying that that's what the problem is here. And she was friendly. She was friendly, it sounded like, to everyone, but she certainly would be friendly to Stanley Liggins. He's someone that she associates with home, someone that she knows, a car that she recognizes. But you have to ask yourself, weren't they just here at the Glen residence together? Couldn't he have had a conversation with her at the Glen residence together? What was going on that he needed to leave the Glen residence and go on 12th Street, which really doesn't go anywhere? 11th Street is the main thoroughfare here, but he goes around, back up north on 12th Street, goes back on 6th Avenue. I mean, that's no way to get to 11th Street. Could have just gone right here. So he's going out of his way to try to find Jennifer because he's having a conversation with her that he didn't want her parents to know about. He's seeking her out. It's reasonable to conclude that this is a setup. A little girl excited about her birthday, wanting to tell everyone. The only problem there is she's got a bike. What are you going to do with the bike? So we got to get rid of the bike. Got to get that back to the house. So this wouldn't be the place to take Jennifer into the car. So we need to concoct another reason to get Jennifer away again. So what happens next? Well, the little girl who was so excited to see her friends, to be on her bike, her prized possession, goes back home to the Glen residence shortly after leaving. She's so excited. Remember this? That's so excited she runs her bike into the porch. And Joe Glenn goes out and he helps her get the bike into the home. And then, who returns to the home? But Stanley Liggins. Again, the guy who said, I got places to go, people to see, he comes back shortly thereafter. And that's when the gum gets mentioned. And again, he's in a car, he's got a car, he was out and about, could have found a quick shop or gone to Max himself, get himself a pack of gum. But no, he returns to the Glen residence and begins the search for the gum. And a grown man needing juicy fruit here. So he says to Joe, you got gum? Joe doesn't. Joe asks, Sherry, you have gum? She doesn't. Then, what helpful little girl who knows perhaps there's a plan for something special that they plan back there in front of Mrs. Pemberton's house? Get her away. I'll go to Max and I'll get some gum. And what does she have? She goes to her mother and asks, can I go get Stanley some gum? She's got a dollar bill in her hand and says, I can keep the change. So Sherry agrees that she can go to Max, come right back, go get that gum. Jennifer knows she has to be home by the time the street lights come on. So Jennifer leaves on foot, without her prized possession, leaves on foot to walk a block and a half to Max Liquors. It looks like about a block and a half to Max Liquors. That's where she goes. And that's the last time Sherry sees Jennifer alive. At that point, Sherry goes into the bedroom to breastfeed Damien. We heard about that. And when she goes into the bedroom, left out in the living room when she goes are Joe Glenn, Nate Roden, Eddie Z, John Brown, and Stanley Liggins. Obviously, Sherry's in the bedroom, Joe's in the living room, and at some point, Stanley slips away, doesn't wait for the gun. And there is this production for him to get. He slips away. And so now we follow Jennifer to Max Liquors, where Jennifer is seen by Charlotte McCrae, who knows Jennifer, talks to Jennifer, comments on how pretty Jennifer looks with her new dress, and wants to interact with Jennifer. And what is Charlotte told? I'm in a hurry, Mrs. Mack. I gotta go. She's getting her gum. I have to get this to a friend. But remember, it was Mrs. McCrae's testimony was presented again via transcript. And it was the defense who read in her deposition transcript. And recall that in that transcript, Mrs. Mack testified, I'm in a hurry, I have to go. My friend is waiting for me outside. She has a friend waiting for her outside. Those were the last words that Jennifer spoke, according to Mrs. McCrae. And she leaves. At the same time, Jennifer is at Max Liquors. Antonio Holmes goes to Max Liquors to get a quart of beer. He sees right there on the side, right near that ice sign, on the side, maybe the southeast corner of Max Liquors, or the northeast corner of Max Liquors, right near that ice sign, as Antonio Holmes is going in, he sees Stanley Liggins standing outside. He interacts with Stanley Liggins, says a greeting, how's it going? Stanley Liggins remarks something to the effect, okay. Then Antonio Holmes goes into Max, where he notes what's going on between the little girl with the dress, with the yellow pack of gum, and Mrs. Mack. When Antonio Holmes leaves, he doesn't see Stanley Liggins. He doesn't see Jennifer. And those were the last observations of Jennifer alive. Now we move to Jefferson School in Davenport. As we observe State's Exhibit 2, which is an easterly view, looking east. The school's not on here, it'd be down off here to the bottom. We're looking at the 12th Street as it curves into Vine. And Jennifer's body is right here in this area on 12th Street. And that's the next location we're going to talk about. We can't, at this point, talk about footsteps of Jennifer, because at that point, Jennifer's not alive. Her footsteps have ended. We know, based on the testimony of Lloyd Eston, that a reddish car was parked at approximately 8:15 right off of 12th Street here before it turns into Vine. Lloyd Eston and then Wanda Hughes both see the defendant's car at this location. Lloyd Eston says he's making his way down 12th Street heading east at approximately 8:15, and he's going to turn onto Vine Street. And he sees a reddish car parked with the trunk open, doors open, and a man standing behind the trunk. And the man is standing in front of the license plate. He can't identify the race of the man. Lloyd Eston continues to drive. Lloyd Eston doesn't note a fire. There's no fire. We do know, though, that at 8:16, Christina Olson does see a fire in that location. Wanda Hughes also sees a fire in that location. Then she describes a car that she sees driving on 12th Street, turning on Vine, and stopping at a stop sign on 10th and Vine. And she describes the car as distinct. Lloyd Eston identified the car that he saw on September 17th at approximately 8:15 as the Peugeot. Wanda Hughes identified the distinct lights that we see in this still photo from State's Exhibit 86B. That was the video that Wanda identified in front of you as the very distinct light she saw stopped at the stop sign at Vine and 10th. And she testified, and you saw the vehicle yourself. Again, you saw photos of it that I've shown you. You saw Exhibit 86B, the video, and you saw Exhibit 86 itself when you viewed it in the police garage. You note how very distinct this car is, how rare a type of car it is, being a Peugeot, and this distinct nature, not just of the lights of the Peugeot, but the particular taillights of this car. So we know that Christina Olson sees that fire at 8:16. And then we know that Wanda Hughes saw it. And then next, who sees the fire but Michael Brown, the parent who testified that he was at first a dad's club meeting, then at the PTA meeting to stop in. I think he said that the PTA meeting ended at 8:45 approximately. And he goes outside and he sees what he thinks is a trash fire. And he goes back to the school and notifies Randy Stender, who is the custodian, maintenance man at the school, who, even though he's told, call 911, there's a trash fire, he's thinking, we don't need to bother the fire department with this, I can put this out, I can stamp this out. Goes down, is proceeding to try to stamp out the fire and learns the horrific fact, this is no trash fire. This is a human being on fire. This is a little girl. And And so Randy Stender runs back to Jefferson School. Remember, he has a mother from the PTA drive him down to see, is this really what I saw? I need some headlights to see. Confirms for him that that is indeed what he saw, that horrific sight. And goes back, running back to the school. At that point, someone else had called 911, and the fire trucks were on their way. They were approaching along 12th, heading east. And what does Randy Stender do but run ahead of them to try to guide them to where they need to go, to this horrible sight. And so then the Davenport Fire Department arrives. They observe the gravity of the incident, the gravity of the situation that they see. They spray very gently with water so as not to disturb any evidence. They put the fire out and they begin securing the scene. And of course, at that time, the Davenport Police Department is arriving. And the investigation begins. Because what the Davenport Fire Department saw, and what the Davenport Police saw, and what Randy Stender saw was not trash. It was a little girl. And based on the facts and circumstances and what they saw, they suspected that what they had on their hands was a murder. And the investigation began. So at that point, we know that Jennifer's footsteps ended. The police footsteps began as they worked their way through the investigation, as they worked to solve this murder. What I'd like to do now is to review for you the law with regard to murder in the first degree, the crime that Mr. Liggins has been charged with. Now, as I'm reviewing the law, and Judge Grieve has already read it to you, and told you what the law is, I think it's important to review it, even though I predict that the defense is not going to contest that Jennifer Lewis is the victim of a murder in the first degree. I don't believe they'll contest that. They probably won't contest that she's the victim of a sexual assault. And they probably won't contest that she's the victim of a kidnapping. But it's important to review the law. Then, we're talking as we view Jennifer at her autopsy, what they were looking at in the investigation, and what led them to know it was a murder. I want to review some basic law, some general concepts of law before we talk about what the elements of the crime are of murder in the first degree, the essential elements. Instruction number 33, and I think this is probably something you're wondering. We have a lot of talk about Illinois here. We know that Jennifer was last seen alive by Mrs. McCrae, by Antonio Holmes, at a liquor store in Rock Island. So let's take a look at what the law says about that. Instruction number 33 tells you that an offense is committed partly within the state of Iowa if conduct, which is an element of the offense, occurs within Iowa. An offense may also be committed partly within the state of Iowa if a result which constitutes an element of the offense occurs in Iowa. The law of the state of Iowa allows a jury to infer that if a body is found within the state, infer that if that if a body is found within the state, here's where I have, it looks like there's always a typo. I always have the actual instruction. The law of the state of Iowa allows a jury to infer that if a body is found within the state, the death occurred within the state. If a body is found within the state of Iowa, the death occurred within this state. If you find that Jennifer Lewis's body was found within the state of Iowa, you may, but are not required to, conclude that the death of Jennifer Lewis occurred within the state of Iowa. This is a practical consideration. How is a state to prove exactly where Jennifer's last breaths were? The state doesn't need to do that. You may deduce that her breaths occurred close to where her body was found, her last breaths on earth. And this law allows you to find that if her body was found in Iowa, which again is not going to be contested, that her death occurred in Iowa. Also consider that crimes, especially a crime such as murder, crimes are ongoing, they progress, and instruction number 28 tells you that a person participates in an offense beginning with the first act done toward the commission of an offense and ending when a person has been arrested or escaped from pursuers. So from the first act done until the person has been arrested. So that's as Stanley Liggins was participating in murder in the first degree, from the first act he committed until he was arrested. Also, when you're considering the evidence and the law, there are 4 instructions that tell you to use your common sense. So as a jury, you are encouraged to use your common sense. You'll see that in instructions 3, 8, 10, and 18. Here's another important instruction with regard to basic legal concepts. You may hear before you became a juror, well, that's just circumstantial evidence. Well, circumstantial evidence is to be weighed exactly as direct evidence under the law of the state of Iowa. You see in instruction number 8, facts may be proved by direct evidence, circumstantial evidence, or both. The law makes no distinction between direct evidence or circumstantial evidence. You need to apply, you need to weigh them equally. Also, alternative theories. Again, you'll see that as we review the law of the state of Iowa with regard to murder in the first degree and sexual abuse, that there are alternatives. Murder in the first degree can be proven by premeditation, or that the defendant murdered Jennifer while committing the offense of sexual abuse or kidnapping. So there we have alternatives. This law tells you how to apply that. Where 2 or more alternative theories are presented, or where 2 or more facts would produce the same result, the law does not require each juror to agree as to which theory or fact leads to his or her verdict. It is the verdict itself which must be unanimous, not the theory or facts upon which it is based. So it's the verdict that must be unanimous. We've heard in jury selection about reasonable doubt, and that is the burden that is on the state, and you heard that in the instructions. The burden is on the state to prove that the defendant is guilty beyond a reasonable doubt. Instruction number 18 defines that for you. And I have put a portion of instruction number 18 on this slide. In part, instruction number 18 tells you that a reasonable doubt is based upon reason and common sense, and not the mere possibility of innocence. Proof beyond a reasonable doubt does not mean proof beyond all possible doubt. If, after full and fair consideration of all the evidence, you are firmly convinced of the defendant's guilt, then you have no reasonable doubts and should find the defendant guilty. If you are firmly convinced. So now we are going to get down to the instruction with regard to murder in the first degree, the crime that the defendant is charged with. The element, it's a 5-element offense. It has 5 essential parts. Murder in the first degree, on or about the 17th day of September 1990, the defendant strangled Jennifer Lewis. Jennifer Lewis died as a result of being strangled. The defendant acted with malice aforethought, and the defendant either acted willfully, deliberately, premeditatedly, and with specific intent to kill Jennifer Lewis, or was participating in the offense of sexual abuse or kidnapping. One of those alternatives. 5, the offense was committed wholly or partly within the state of Iowa. So that is essentially the crime of murder in the first degree. And again, the evidence that Jennifer was murdered is, I predict, unrefuted. That she was sexually abused, that she was kidnapped. And here is the charge itself. What is malice aforethought? That's part of one alternative theory, or no, malice aforethought needs to be, that is actually element 3. So that applies to both alternatives. What is malice aforethought? Malice aforethought is a fixed purpose or design to do some physical harm to another which exists before the act is committed. It does not have to exist for any particular length of time. So that tells you it doesn't have to be a big scheme, plotted out and planned. But the question is whether there was a fixed purpose or design to do some physical harm to the victim. Let's look at sexual abuse. Here's the law of sexual abuse. Instruction number 27, that on or about the 17th day of September 1990, the defendant performed a sex act with Jennifer Lewis. That the defendant performed the sex act while Jennifer was under the age of 14 years at the time of her death. Again, it's not disputed what her age is. We know that her 10th birthday was the day she was buried. What is a sex act? Instruction number 29 instructs you as to what is defined as a sex act. Penetration of the penis into the vagina or anus, between the mouth of one person and the genitals of another, between the genitals of one person and the genitals or anus of another, between the finger or hand of one person and the genitals or anus of another, by the person's use of an artificial sex organ or a substitute for a sexual organ in contact with the genitals or anus of another person. I anticipate that this is not going to be disputed, but remember the testimony with regard to Jennifer's autopsy. And here is Exhibit 31. The red portions show you the injury that was done to Jennifer's bladder, to her uterus, and to her anal area. And common sense tells you that that was done by penetration of something into those areas of Jennifer. And common sense tells you that it was done for a sexual purpose. Kidnapping, instruction number 30, that on or about the 17th day of September, the defendant confined or removed Jennifer Lewis, that the defendant did so with the specific intent to subject her to sexual abuse, and that he did not have the authority or consent of her parents to do so. That is the confinement or removal. That's what that applies to. Of course, and no one, or in this case, there's no evidence that parents would give authority or consent to such a horrific act. I guess this answers the question of, okay, Jennifer might have gone willingly with Stanley Liggins, whatever they concocted, the plan that made her anxious to get away. Perhaps it was about her birthday. Who knows? But just because Jennifer may have consented, her parents certainly did not. We know because that had to be set up away from the home. That was witnessed by Mrs. Pemberton and Mrs. Allen Watson and Ms. Hall. Confinement or removal with regard to kidnapping, no minimum time of confinement or removal is required. It must be more than slight. So again, we don't need to put this one on for days. Just that it was more than slight. And you need to consider whether the risk was substantially increased, risk of detection was significantly reduced, or the escape was made significantly easier. I don't believe any of this will be contested, members of the jury. So now that we've reviewed the law, we are back to the investigation that began when Jennifer's footsteps ended. And of course, the investigation began at the scene, but the investigation also led back to that Peugeot and to another important area, and that is the hillside in Rock Island, states as depicted in States Exhibit 5. We know that the defendant was staying at the Hillside Hotel here, this L-shaped building, and he was in room 54, although not in his own name. But he was staying in room 54. We also heard testimony with regard to his vehicle near that hotel, both being parked at that hotel, but also being parked at this apartment building, joining the complex that is the hotel. So even though the defendant stayed in room 54 over here at the hotel, he parked in this apartment building parking lot away from his residence, as described by Brenda Adams.
Folks, if you're anything like me, the word style kind of makes you uncomfortable. At least it does for me. I think of fancy models walking down runways wearing clothes that I would never be caught dead in. I think of it in a way, it's something, that I just don't do. I like clothes that are comfortable and fit well and are attractive. And that's why I really like this company called Stitch Fix. Stitch Fix is an online personal styling service that finds and delivers clothes, shoes, and accessories to fit your body, budget, and lifestyle. Just go to stitchfix.com/suspect and tell them your sizes, what styles you like, and how much you want to spend on each item. You'll be paired with your very own personal stylist who will pick 5 items to send you right to your door. Then you'll try them on, pay only for what you love, and return the rest. Shipping, exchanges, and returns are always free. There's no subscription required. You can sign up to receive scheduled shipments or get your fix whenever you want. Stitch Fix styling fee is only $20, which is applied toward anything you keep from your first shipment. Get started now at stitchfix.com/suspect. You'll get an extra 25% off when you keep all 5 items in your box. That's stitchfix.com/suspect to get started today. One more time, folks. You'll absolutely love this company. Go to stitchfix.com/suspect. It's wonderful. You'll love it. I sure do.
Recall that Brenda Adams testified that the Peugeot parked in spot number 1 here at the apartment. She testified that she saw this the day before she observed the car being towed away from the hotel. We know the car was towed away on September 19th from the hotel. And Brenda said the day before, it was,
Donna Adkins,
Donna, what did I say?
Brenda Adkins.
I'm so sorry. Thank you. Donna Adkins, there added confusion there. Donna Adkins testified via transcript. Remember that? Brenda Adams is the defendant's girlfriend. She appeared live. But Donna Adkins, she testified that she saw the defendant's vehicle as depicted here on the screen in Exhibit 104. Donna Adkins said that she was moving her boyfriend out the day before she saw the car towed away. So Donna Adkins is moving her boyfriend out on September 18th. And she's annoyed because that's their parking place. And she's causing a little bit more work to move around this car. But what else does she say about the car? Donna Adkins said that the car smelled strongly of gasoline. She could smell it as she was walking by it on the 18th of September. She commented, boy, nobody better light a cigarette around that car. And she said, as we see in the slide, that she saw a gas can in the passenger portion of the vehicle, the back seat, passenger portion of the vehicle there on the passenger side. She saw State's Exhibit 96. And again, we see that depicted in this slide. With regard to the hillside, back up a bit, we heard other witnesses talk about Stanley Liggins and the Peugeot back here at the hillside. And these witnesses talked about September 18th, but the witnesses talked about the early morning hours of September 18th. Those witnesses were Thomas Perkins, who was staying at the hillside, and Rodney Sinclair, who was also staying at the hillside. And both Thomas Perkins and Rodney Sinclair testified as to actions they observed by the defendant on the early morning hours of September 18th at the Hillside Inn. Thomas Perkins testified that he went out to get a pop early morning hours, I think he said approximately 3 a.m., and he saw the Peugeot, and he saw the defendant at the Hillside Inn. Rodney Sinclair was staying in the room next door to Stanley Liggins' room and confirmed that from Stanley Liggins' room, he heard the shower banging, which occurs from being turned off and turned on. And Rodney Sinclair heard this, was disturbed by it in the early morning hours of September 18th. With regard to the hillside, we heard the testimony with regard to the garbage bags, which were stored in the publicly accessible storage area below those stairwells, and the garbage bags that were found in those storage areas. And you heard the testimony that their content was similar to the content found attached to Jennifer's body, attached to Jennifer's burnt clothing, that were seen on Jennifer at the scene and removed from Jennifer at her autopsy. But they were both hefty garbage bags, commercial, unusual at that time given their color, and they matched. We know that the Peugeot was towed from the hillside on September 19th and that it was searched. And what was revealed in the search was that it appeared that the Peugeot had been washed recently, because there was no rust, the car wasn't leaking water when they put it through the washing machine, or the car wash. And when they lifted the seats, they observed the wetness beneath the seats, and again, that it appeared to be recent. And let's review the defendant's own statements. Recall the defendant's own statements. First, Brenda Adams, his girlfriend, who testified live. Brenda Adams described the defendant when he arrived at her home at approximately midnight on September 17th, and how strange he was acting, unusual. And that the defendant talked about love, and she said, we weren't about love. That was not what it was about. But all of a sudden he's bringing up love, and will you always love me, and acting unusual. She also testified, by the way, that she smelled gasoline in the Peugeot unit. So that's what Brenda observed, that the defendant was acting unusual when he came to her apartment on September 17th. But then what about the defendant's statements to Detectives Holden and Jennings, and how much of the state's evidence they agree with, and the important ways in which they don't match the documentation we have. The defendant was interviewed 2 days after Jennifer's murder. The defendant stated that he picked up Tim Barber at approximately 3 o'clock. They drove in that Peugeot to help Timothy Barber cash the check. They went to a bar, and Stanley Liggins told detectives that he stayed at the bar till about 5:30, and that after that, he went to Ace and Sherry's household. Stanley Liggins told the defendant that he arrived at approximately 6 p.m. Stanley Liggins described others in the household that were there, including Jennifer, and during his interview, the defendant volunteered that Jennifer was wearing a dress that went below her knees. During the interview, initially, the defendant said that he stayed about 40 to 45 minutes, that he sent Jennifer off to get a pack of gum for him and gave her $1. He said he waited 10 to 15 minutes for the pack of gum but left without getting it. That he had to get home to make a phone call at his apartment. Stanley Liggins told the detectives that he went back to his room at the hillside, and that he called that Liggins' household, his brother and his sister and Sheila Nimmers, and he called that household. But there's no documentation of that, because you will not find it in those hillside records. And there should be documentation, because he said the answering machine picked up. I don't talk to answering machines. So there's no documentation of this call that the defendant claimed he made. The defendant claimed he called Ace and Sherry at about 7:45, which we know there was a call at 7:38 to Sherry and Joe. The defendant claimed to the detectives that he wanted to see if Jennifer had returned, and he learned that she had not, and he said he would be by their house later. The defendant told the detectives that he drove back to the Glenn household at approximately 8:45, that he learned they were unable to find Jennifer, and that he advised them to call 911. That he left the Glenn household and went back to the hillside while Sherry was on the phone with the police. That he called his girlfriend Brenda, and the defendant said that he arrived at Brenda's house before 10. Although Brenda said it was noon. Now, at that point, Stanley Liggins is confronted by the detectives with the fact that you were seen talking to Jennifer earlier by people in the neighborhood. Because, of course, the defendant had skipped that part of his activities that day. So the detectives gave him a chance to say what happened, and then they confront him with the fact that people saw you talking to Jennifer earlier. And so then Stanley Liggins says, oh, yeah, I did. I didn't want to tell you about that because I was afraid you'd see Stephanie. But he acknowledged that that in fact had happened. Detectives asked Stanley Liggins about the gas can. And Stanley had said, well, I had that gas can and I used it months earlier to help some women who had run out of gas. But you also saw the tests. You learned about the test that was conducted regarding the gas can, and that it would be empty by the time it was discovered on September 19th in the trunk of Stanley's car by investigators. Because they said there was some gas left, but it couldn't have been from months ago. As you heard Lieutenant Schaefer, and then the experts say it would have evaporated in that time. The defendant had acknowledged that Jennifer had been to his apartment before. And then, what about the statements that the defendant made to Frank Rising, who you had a chance to see, who testified here, who told you that the defendant told him, maybe I did it, but they can't prove it. And you saw how Frank Rising reacted to that. Now what we're going to do is back up a little bit in the timeline. Because last we mentioned at the Glen home with regard to Sherry and Joe. We leave Sherry in the room breastfeeding Damien, and Joe's out playing foosball. So now let's talk about when Sherry comes out of the bedroom. Everyone's gone but Joe. Jennifer's not back. And Sherry and Joe are talking to each other about where's Jennifer. Street lights are on. It's getting dark. It's well past time for her to be home considering the short distance. And Stanley's not there waiting for the gum. He left. And that's when that call was made at 7:14. The first call made to find Jennifer. That's to the Titus home at 7:14 p.m. looking for Jennifer. And that's when the search began for Jennifer. That's when we know that Sherry started looking for Jennifer where she expected Jennifer to be with little friends, maybe got carried away, wasn't paying attention to the time, and so Sherry tells you that she went to places that she believed Jennifer would go, and that she would keep going back to the house, but she wouldn't stay away very long. She would go around the neighborhood, get back, see if Jennifer was back, but no, who was back there? Only Joe and Damien. And she did this on 2 or 3 occasions. Then she finally calls Mrs. Mack at approximately I believe that the data will say, the telephone records will tell you it was at 8:42 that she called Mrs. Mack, and she learned that Jennifer was indeed there and had left. Then we know that Stanley shows up, and according to the Glens, when he hears that Jennifer is missing, says with a chuckle, "You better call 911," and leaves. Doesn't offer to help his friends look for their daughter. Doesn't offer to look for who you might have thought was his little friend, the little girl he was concerned about. Didn't offer any help. Chuckled, "You better call 911," and left. And then we know that indeed the phone call was placed to the police, the Rock Island Police Department, at 8:54. And that is when the investigation on the Rock Island side begins, because we know that Bruce Johnston showed up, got the report from the parents, got a picture of Jennifer, went around to the neighborhood to look for Jennifer, but at some point during this is when he learned that a little girl was found dead in Davenport. And he was instructed to go back to the Glen home and keep them there until additional detectives could arrive. And that is when he did a little cursory search himself. He knew there were accelerants involved in Jennifer's death. He got close enough to Joe and Sherry, didn't smell any gas, went into the bathroom, checked out the towels, didn't smell any gas, and then he stayed with them. We know that Joe, too, searched for Jennifer. We know he was yelling for Jennifer with Sherry on the porch. Doris Dorman testified with regard to that. We also know that he went himself on her bike at first, and then Mark Titus loaded the bike into Mark Titus' vehicle and helped with the search as well. And it was at some point that Mark Titus and his brother came back to the Glenn household, and they said what they had heard on the news. The brother, Mark Titus' brother, said what he had heard on the news, the horrible news that a little girl was found dead in Davenport. And Sherry obviously became very upset. Obviously, when the Titus brothers come and Sherry learns the news, the body found in Davenport, she doesn't know that there's a connection. She fears that there's a connection. But she is indeed later told that there's a connection between the little girl found in Davenport and Jennifer. She doesn't want to believe it. This is the little girl that she was searching for. This is the little girl that she hoped to see again. And this is the little girl that she saw laying dead in a morgue in a hospital in Davenport. And then she had to believe that indeed Jennifer was gone. Members of the jury, you have two instructions that tell you your sole duty is to find the truth and do justice. The evidence and the law lead you to the conclusion that the defendant, Stanley Liggins, murdered Jennifer Lewis on September 17th of 1990. The defendant is guilty of murder in the first degree. The evidence and the law will guide you. I ask you to return a verdict of guilty of murder in the first degree. Thank you.
Iowa Public Defender Aaron Habacher then made his case for why Stanley Liggins should be found innocent.
Well, folks, this is the last time I get to talk to you, right? Maybe you're happy with that, I don't know. I get to talk to a jury selection, and I get to talk now. And the reason I bring that up at the beginning is, now I joined, and Ms. Walters, thank you for the service. This has been a long slog, no question about it. But the reason that I don't get to talk again is because I don't have to say a thing. Right? And that's the thing I impressed upon you at the beginning. I hope at the beginning during jury selection, that burden of proof thing. And that's why you'll never hear from me again. So part of the purpose of this closing argument, from my standpoint, is to hope that you'll carry through some of the things that we talk about, because I'm not going to have a chance to talk again, assuming the state exercises their rebuttal. So in part, it serves two purposes, me arguing and me trying to anticipate what further argument can be, which can be difficult. We joke around, well, even before I get to that point, one thing I want you to understand is that there is that instruction that's out there, and all the instructions that you've been given, that's the law of the court. If I say something that's contrary in those instructions, you rely on those instructions. If Ms. Walton or Mr. Walton says something that's different than what's read in those instructions, you rely on those instructions. The circumstantial versus direct evidence, that instruction, the last sentence of that instruction says you decide what weight to give to the evidence. They're not equal. There are different types of evidence that you consider both of them, but then you decide what weight to give it. Everybody knows if you have a video of something, that's pretty compelling. Everybody knows you got 10, 15 witnesses seeing the same thing, that's pretty compelling. You're going to give that more weight than simple circumstantial evidence that might tend to point towards something. The circumstantial evidence is easily explained away by other things, which is exactly what this case is about. Nothing but a chain link after a chain link after a chain link after a chain link to try to connect the dots to Mr. Liggins. But as we all know, the problem with the chain is it's only as strong as its weakest link. And the links in this case have to withstand the test of beyond a reasonable doubt, the highest standard that we have. You know, you haven't been in charge at this point. You've been settled in and out. You've been having to sit there and listen, and about the only thing that you can do is absorb. And you didn't decide how to investigate the case. You didn't decide what charges to bring. You didn't decide what evidence you had to see. All those decisions have been made for you. That's all over now. Now you are in charge. You are in charge to make the final decision. and that is whether the state of Iowa can prove this case beyond a reasonable doubt. And before I even talk about a single fact, this case has raised more questions than it has provided answers. This case has made more holes than can possibly be filled. Before I say a word, that standard, that proof beyond a reasonable doubt to sit there and condemn a man and convict a man for this crime does not exist before I say a word. It is impossible for me, and I will not do it, to talk about 3.5 weeks of evidence. I'm not going to do it. I'm not going to talk about every little bit. But I know that you're paying attention, you have those details, and rely on your own way of thinking, a way of examining the evidence to deal with something. If I skip it, that doesn't mean it's not important. You are in a unique opportunity, despite the length of this trial and despite where we're at procedurally. You are in a unique opportunity to right a wrong that has been in existence for 28 years. For 28 years.
Your Honor, I'm going to object. That is improper argument.
You should rephrase that.
I'll move on. Now, before we get into that, we did talk about a couple of rules at the beginning, that this world is different than the decisions that you make on a daily basis. The daily basis where you kind of go, well, should I do that? Should I buy the car? Should I have kids? Those sorts of things. The rules are different here. You have to have those different lenses to view the facts. And those lenses mean that you're testing the evidence, everything that they've presented with that test of what a beyond a reasonable doubt is, to see if they can cross that bar. Remember the bar, the high jump, and the things that we talked about. And thankfully, the court defines what beyond a reasonable doubt is. Again, look at the whole instruction. Ms. Walton pointed out about what firmly convinced is. Firmly convinced is if you don't have any reasonable doubt. Before that, thankfully, reasonable doubt is defined. A reasonable doubt means a reasonable person would not hesitate to rely upon that evidence, would not hesitate, pause, have concern about relying upon the evidence to convict somebody. That's what reasonable doubt is. And at every step of the way during this case, every step of the way, the minute a witness got off the stand, the minute testimony was concluded, there was reasonable doubt. Each time with each witness. The burden is not on the state to prove whether on September 17th of 1990 a terrible crime took place in Davenport, Iowa, or Rock Island, Illinois. It doesn't matter. That's not the burden on the state. If that was all that had to happen in a criminal trial, we would have been done a long time ago, and we could have saved everybody a bunch of time. The crux of this case, and Ms. Walton is absolutely correct, is whether or not there's sufficient evidence beyond a reasonable doubt to show that Mr. Liggins did it. And there is not. But in order to effectively examine that evidence, what we have to ask you to do is check your emotions at the door. Hard, I know that. But it's easy to want to punish somebody, and somebody needs to be punished. But more importantly, the right person has to be the person that is convicted of the crime. It is equally bad to have the wrong person convicted. On September 17th of 1990, the crime was discovered. On September 18th of 1990, Joseph Glenn, at those times, these are their names, and Sherry Glenn were interviewed. On that Thursday, there was a press conference held by the Davenport Police Department, which says, we have our suspect, we have our man. And Mr. Liggins' picture hits the paper, a description of a car hits the paper. The Davenport Police Department, just a couple days later, decided that's our man. Despite the fact, knowing that while there are substantial community pressures when something that serious happens on the police department and law enforcement to get it right, you don't want to release that information and taint the investigation. Officer Kern said as much. It's that thin line. It's trying to balance the two. The line was crossed. This commitment it must be Mr. Liggins. This commitment by the Davenport Police Department that it must be Mr. Liggins on that Thursday meant everything was tainted from there on out. Think about it. That decision was made before Wanda Hughes was ever in the picture. That decision was made before Antonio Holmes was ever in the picture. That decision was made before Ms. Pemberton did the ID on the 21st, because that Thursday was the 20th. And then what happened from there is each step along the way, when they tried to investigate and prove that this conclusion was correct, they ignored evidence that would exonerate Mr. Liggins and tried to amplify any evidence that might suggest otherwise. That has been the history of this case. And even after the interview with Joseph and Sherry Glenn at the time, they're not pointing the finger in any strong way. The parents of this child at Stanley Liggins. He is mentioned, his name is mentioned, along with the other names of the individuals that were at the house, because that was part of what the investigation is. You try to see who was around at the time. Fair enough. But Sherry Glenn, confirmed by Joe Glenn, when asked, and in a cheerful way, you heard it, about anybody that may want to harm Jennifer, she gave them the name, Paul. She gave them a name, Paul. She described the circumstance of Paul and his friends. It's a little gobbled. I won't disagree with that there. There was definitely some sort of conflict between Paul and his friends and Sherry and Joe and their family. So much so that this Paul threatened the family. And so much so that this Paul, as part of the threat to that family, had followed Jennifer Lewis home from the bus stop. Followed her home within a month before Jennifer Lewis disappeared. Within a month. Told by both parents. And it wasn't just Paul. There was a physical description of who Paul was. And there was a possible address about who Paul was. And we know that they can find people with much less. They found Wanda Hughes. It was an anonymous tip. They went and looked at the address. They traced it to her. We know that Davenport had the ability to do it. We might have found out that they couldn't if they had lifted a finger about the investigation on Paul. But they didn't. Officer Lindbaum, the importance of those detailed reports, putting in everything that took place, wasn't in his report. It was not in his report. But we know it happened, because thankfully, they were capable of taping that interview, unlike Mr. Liggins and many others. They were capable of taping it. So those reports that you rely on and everybody else relies upon, higher up to dictate where this investigation goes, huge gaps of important information in that report. And instead, the interview tape is tagged with evidence and put in the locker. And the report goes on. Name one law enforcement officer up to and including Lieutenant Schaefer that says they excluded somebody named Paul. Name one person that says they knew about Paul other than Lindbaum, who forgot, but we now know it's true. It was buried and it was never examined. They knew that on the 18th. Then they pursue Mr. Liggins later without asking the basic questions about investigations. Basic questions, why something happened? Why? There's no reason why Mr. Liggins would be responsible for this. As Mr. Walt pointed out, he's a friend of the family. He was friendly with the family, which is why it wouldn't be unusual if he was meeting with Jennifer or talking with Jennifer. He was a nice guy. If he's giving her the dollar and saying, keep the change, that would be just a nice gesture for the kids. He knew them for a while. Mr. Glenn was in jail. If he was of this ilk, and this is something he intended, wouldn't that have been the time to do this? There's no reason. It is out of the blue. He wasn't a stranger. They took their young son over there to see him. Not a stranger. And not somebody that showed any signs, anyway, that number one, they would have any interest in something like this, or number two, be morally capable of some act like this. Zero evidence. Zero. Moreover, Mr. Liggins did not in any way, shape, or form act after the police are at his door in any way like a guilty man. Cooperates with the search, cooperates with the search of his apartment, with the search of his person, agrees to go down and out. All things he didn't have to do. Police officers say he was absolutely cooperative, he wasn't combative, he wasn't trying to do anything like that. And then he goes down to the police station, gives a statement, is willing to do that, one that we don't have the benefit of the recording, lest there might have been a misunderstanding about who these phone calls were to or what they were for, or how much gas he evidently poured out. Right? We don't have the benefit of that. But he willingly does that, and there's no question amongst law enforcement and you all that there certainly was no confession in what one way or another in that time he went down and talked to him. It means nothing to show guilt. In fact, the contrary verse is true. The fact that he was willing to do it and go down and speak willingly, and if they're saying there was little deception, it's minute at best. He was willing to do it, which it seemed to me to indicate that that's not the conscience of a guilty man. So they can't answer the why for Stanley Liggins. You can't answer the where. Simple questions. Where? It appears to be clean. Underneath the cushion of the Peugeot. It appears to have been clean. Clean with what? It's wet. Right? There's no indication there's bleach, any solvents, any cleaning materials, no wet sponges, no nothing. Clean with what? Ignoring the fact that Brenda Adams confirms that the back window on that vehicle was busted. They had to put plastic on it. It wouldn't roll up, and so water could get in when it rains. And where's the scientific test on the age of that stain in the car? They're able to do it with the amount of gasoline. No, it's the observation. It appears to have been there recently. That's not proof that that's where the crime happened. Also, makes no sense. You're in that car, presumably you're out kind of in the public. You know, people can walk by, people can drive by, depending on where you go. Makes no sense. And you saw how small that car is. You went and walked by half of it anyway, right? Then there's the question of when. Again, the simple investigative questions. The question of when. There's not a single witness in that household over at the Glens that can give you a specific time. Left soon thereafter, could have been around this time. I think it might have been. I'm gauging it off of 542. I don't know, okay? But how do you put together a timeline like that? When we know to get over to Davenport and back and forth from there, because they talked about it, it's getting roughly a half hour, 25 minutes to a half hour just to do the back and forth. Remember that when you're looking at times and the phone calls from Hillside and things like that. The opportunity to do this. And it assumes you know how long the crime took. The only thing that we know is how long the trips take. You don't know how long the crime took or the cleanup took, which are all alleging took place somehow in this small window of time. So when you have this person identified on that Thursday before they developed any evidence down the road, not be able to answer the simple question of why, cannot answer the simple question of where, and cannot solve the riddle of when, then you must have the wrong who. But instead of acknowledging that, they persisted. And think about the importance of that omission, glaring omission in Limbach. When we're sitting here asking ourselves the why, the when, the where, if they had investigated the Paul and the friends, we might have the answer to the why. Actually, we had the answer to the why, according to the Glens. There was some conflict happening between that family and those individuals. We might ultimately have found out the where and the when if we would have investigated. Because it sits right now, we have no idea where this crime is. We have no idea where this crime scene is. And you remember the timing of that? They had the opportunity. I think Lieutenant Schaefer testified after Lindbaum. Say maybe it was discussed at one of those 4-hour meetings that you don't have reports on or something like that, but nothing. Absolutely silent on it. Because the truth is, that name was given, those details were given. No steps were taken ever by law enforcement to look at it critically. And nobody even went back to reflect, oh my gosh, maybe we don't have the right guy. Even after they kept hitting dead end after dead end after dead end with Mr. Liggins. Because they had that pressure from the community, they already committed to him, they plowed ahead. Talk a little bit about some witnesses, the Glens, just real quickly. We know that they can't put specific times on things and that sort of thing, but if the place your child's going, your 9-year-old daughter says to you, your 9-year-old son says to you, Mom, can I go to Max Liquor to go get some gum? And you say yes. And that child doesn't come back. Where's the first place you go? Max Liquor. Where's the first place Officer Johnston went? Max Liquor. Because the information they had was she was going to go to Max Liquor. Any parent would have walked out that house, taken the trail that Jennifer always took, walked out that backyard, walked through those trees, walked through the parking lot of the gas station, walked across the street to make sure she wasn't on her way back, and walked and talked to Charlotte when she came up missing or they got concerned about her, which was around when it started to get dark because she didn't come back, which was a little after 7. Didn't happen. It did not happen. The only thing that happened, Charlotte McCray never says she saw Sherry that night, okay? And the only phone record you have, Miss Walton is absolutely right, it's 8:42. 8:42, one phone call to Charlotte McCray, 8:42, nearly 2 hours after they had a concern. Now you remember, that was on the 17th. Stan's not a suspect. Nobody's thinking gum or anything like that, but they clearly had not thought at that point that the disappearance of Jennifer was related in any way to her going to Max. They knew something else. Could have been part of that beef with Paul, the conflict that they had. And it's one thing to suffer the loss of the child, especially in such a brutal manner. It would be another thing, too, to believe that her death was a result of some conflict that you had with another individual. They weren't in control of the investigation from that point forward. When the Davenport Police Department took it over and said, Stan's our man, those parents aren't in control of that. They're not in a position to further investigate Paul. They had done what they were supposed to do and probably were a bit relieved that the investigation was taking them towards Mr. Liggins so that they wouldn't have to deal with whatever the relationship was with Paul and his cohorts. The Glens cannot really account for each other. We know that Sherry is in that room breastfeeding for an hour to an hour and a half. She has no clue what's going on outside that bedroom at that point. There is nobody that sees Mr. Glenn during that time out on the porch yelling. The only testimony that we had was from Miss Dorman, I believe, that says she didn't see anybody out on the porch yelling, and they didn't come by until between 8:30 and 9. Again, use your memory, not mine, but it was not at 5 or 6 or 7 or anything like that. So there's no accounting for what happened at that house during that time frame. Miss Pemberton and the individuals that saw Mr. Liggins in the car talking to Jennifer, again, acknowledged by the state, not unusual, but instead it's trying to conflate and exaggerate. Oh, but why did he go here? Let me point something out to you. The first assumption of the importance of that is, what does soon thereafter mean? How long did he leave after Jennifer got on the bike? What does soon thereafter mean? 5 minutes, 10 minutes, 15 minutes? Nobody knows. Okay. What does I've got to go somewhere mean? Where? What's the route? Do you know? Nobody does. There's no testimony about that. Where's the testimony that he would have known where Jennifer was going? Instead, he happened to run into her and talk to her. But what they want you to do is make every negative inference possible to try to say a man is guilty of a murder. Inference from circumstantial evidence. That is not enough. Mr. Edson saw the vehicle. You heard the testimony. Mr. Schaefer said, hey, if somebody was down there and there wasn't a fire at 8:16, then we discounted it. Or if we're talking to people about 9, we're not going to worry about it because we know that fire started at 8:16. We had a rock solid time. Lloyd Edson, 8:15 to 8:30, says he saw a car, never saw a fire. He's not discounted. And what did he see? He saw a car. He never said that was the car. He said the car looks similar. Right? Did Mr. Edson ever identify any lights that looked funny? Nope. The other thing that's lacking in the investigation, because they kind of like what Mr. Edson said, is did they talk to his wife? She was in the car. Nope. Couldn't confirm it. Didn't. I'll show you a couple of exhibits. It's an unusual car, and those taillights are unusual. This is exhibit 104. I'll talk to you about it in a minute. It's about Donna Atkins, and this is exhibit 69. 2 different cars, kind of unusual looking, square taillights. Nothing unique about that car. Not back then, in 1990s. He says a reddish car and it looks similar. That's all he says. Miss Adams. Again, we're trying to connect the dots, but there's a problem with every dot. She doesn't smell the gas in the car. She claimed to smell the gas in the car when she went out early that morning on the 18th to go get a cigarette or something like that, okay? And they tried to make hay with, well, you weren't in it, but she sat in the car. She said she had to get into the glove compartment. She sat in the car. She got in the car. No gas, no smell. There was also some indication that the smell was only when it was being driven. and it's mechanical, as opposed to something that was sitting there. No gas can. She says that Mr. Liggins stayed the night. If Mr. Liggins stayed the night and there's no shower at 3 o'clock in the morning or 4 o'clock in the morning, there's no buying a pop can and seeing Mr. Liggins, there's no somebody almost getting rear-ended, if she stays the night, and she confirms it, because the law enforcement had some doubt, hey, what did you do the next day? She had the car and went and paid her phone bill. It's in evidence. She had to produce it, said, I had the car the next day, that morning. Which also probably means that's why Mr. Liggins couldn't make his meeting with Mr. Roden. He didn't have the car anymore. Says he's in a strange mood. Doesn't smell gas on him. Acts stupid when he's been drinking. We know he was because he's with Tim Barber. And at the time, she acknowledged that not long after that, she found out that she contracted the venereal disease from Mr. Liggins, which could also explain the strange mood in his dealing with her. So just as much as they want to say it points towards, and what's a strange mood mean anyway? After something that's done, how do people behave after they've done something like this? Right? The testimony about the pipes at the end, you heard it. No testing was done if it was 1 room over or 2 room over or something like that. If he's at Mrs. Adams, he's not there. Seeing him in the parking lot, the same problem. The reverse and the attitude of that witness saying it looked like somebody that was in a rage or something like that. Well, how somebody looked when they almost hit somebody in a car? If you believe his testimony, Mr. Liggins was backing up from the other side of the parking lot before he got to the exit of the Hillside Inn. Again, they're trying to flame these up and make these bigger than they actually are. Every little thing they want you to infer the worst. But just take one time and not infer the worst from any one of those links in the chains, their case falls apart. It falls apart. On September 20th, they committed the stand. And when they continued with the investigation, finding time and time again that they couldn't link it to Stan, then evidence, what was clearly meaningless, somehow was trying to be argued to be important. Case in point, Donna Atkins. Donna Atkins. Dennis Kern says, they didn't really know Hillside from the Hill Beans. Didn't say that, but he didn't know Hillside Inn versus Hillside Apartments. Remember that? So they got excited when this Donna Atkins called in and talked to Lieutenant Schaefer for that long time where there's no report and said, aha, we're going to go set up where Donna Atkins says Mr. Liggins was parking all the time and he was in the way, and when we were trying to move my boyfriend, we could smell gasoline in that car, and that's the gas can. As if Mr. Liggins owns the only Eagle gas can in Davenport or Rock Island at the time. All right? She was confident about that, so they went out there and they staged it at these apartments. When we know Mr. Liggins lives a long way away across 2 parking lots at the Hillside Inn. And they need this, because that's where they found the bag, right? But instead of realizing that Donna Atkins must have been mistaken, that that was not where he was living and that's not where the car was going to be, they're attempting to put those 2 things in front of you and say, no, believe this. Believe this. And that was early on in the investigation. They could have stopped or rethunk it, they didn't. She's with her boyfriend, moving back and forth, moving. Where's the boyfriend saying? You can smell gas, don't light a cigarette. Also, she said it was on the 15th or 16th, a day or 2 before. Wanda Hughes. Wanda Hughes. The one and only time that she talked to law enforcement was in October. And when Wanda Hughes talked to law enforcement, we heard Lieutenant Schaefer talk about what was in Mr. Murphy's report. Mr. Murphy was no longer with us. She never mentions a car. She never mentions a fire. She never mentions lights. And this paid drug informant then, in questioning for Mr. Walton, Mr. Schaefer indicates that the first time that she talks about those things was in a deposition. So after Mr. Liggins has been charged, after Mr. Liggins has counsel, it's the first time that she says something about this. Now, who else verifies those lights? It's just Wanda Hughes. Said nothing about it in October. Find out she's a paid drug informant. She does it in depositions. Did anybody surveilling the car? Law enforcement verify the condition of those lights that Mr. Hughes was seeing, that you saw out in the garage? Did Brenda Adams verify that? If anybody knows about driving without good lights on, I don't know how that car got around town without getting pulled over every 2 seconds, because most of those lights weren't working as you saw them in the garage. Not a single individual verifies what Miss Hughes says. Not law enforcement, not anybody. And you remember, she called in as an anonymous source about 1301 Vine. Without any information about car fire or anything like that. She was an anonymous source about 1301 Vine. And they had to put 2 and 2 together to find out that she was the one that made the phone call. Also, I don't have any doubt that she had fine eyesight back there. You can look at that map, it's a long way from where she was on Vine to where we're looking down there. And I'm not entirely sure she had bad eyesight in that courtroom, because when we were in 301, which is twice as big as this, she was calling out and identifying somebody in the very back of the room. Reasonable doubt? Yes. Antonio Holmes. Played that interview for you again, so you could hear his voice and you could see what was happening in that room. Recall, he came in the day before and they said, Eureka, he's identified Mr. Liggins. Comes back on his own, by the way, on his own the next day. They didn't bring him back. Comes back on his own the next day and says, look, I was drunk. I need to tell you, I'm not entirely sure that that's the guy. And you remember, there could have been somebody else standing outside of Max Liquor at the time. The janitor was there working outside. That's what Charlotte said, right? But we don't know that person. There's no investigation, no evidence that said they wouldn't talk to him, but there were other people that it could have been. And he comes back in, and there are law enforcement officers in the room. It's on the tape. They are shoving the picture of Stanley Liggins in front of this young man's face who came back in voluntarily saying, but doesn't that kind of look like them? And he's adamant saying, I'm not sure. I'm not sure. And that is how it ended on the 21st or 22nd of September. Then miraculously, in November, it's in the exhibits, November of 1992, I believe, Mr. Holmes was in trouble. He was in jail. He took a deal. I believe it was in exchange for truthful testimony. There was no evidence that he was testifying of anything else. And then he took the stand and took an oath and said he was sure then, 3 years later, after he took a deal. That is the type of testimony that is inherently unreliable. Inherently unreliable. And it's the type of thing that makes you go, it should make you feel uncomfortable, and you should be uncomfortable. Last but, Frank Rising. One of the instructions on there is that when you hear witnesses, if you can believe any or all of it, and my argument is you shouldn't believe a thing that comes out of Frank Rising's mouth. He was a lifetime con man. He clearly did not like Mr. Liggins, called Mr. Liggins boy. He thought he might get something for it at the time, even though he's a little upset that he didn't, that he was going to get some advantage at the time by saying something. It's not even really a confession. I'm not entirely sure those words that he says he said were a confession. And what's incredible about it is that he just miraculously gets put in this cell with Mr. Liggins. He doesn't quite understand why he does at the jail. Spends this time with them, weeks at least, with Mr. Liggins. They don't say boo. They don't say a word to each other, according to Mr. Rising, except for this. Dan says what he says he said. And that was the only communication that he had with Mr. Liggins. Incredible. As in not credible, not believable, no way, proof beyond a reasonable doubt. Number one, that he said it, or that it exists in a confession in the first place. Think about it. As old as this case is, one person saying, Frank Rising, saying, I heard that. And quickly, adopting this evidence that really means nothing, of Frank Rising and Antonio Holmes or Wanda Hughes, not credible, couldn't have been seen, nobody corroborates it, and yet ignoring other things that might exculpate or show the innocence of Mr. Liggins. Roberta Cadera shows up. It wasn't at 8:16 when they were out there, but she does say that she sees an individual with long hair, with leather coat, sees some shiny stuff on it at the time, at the scene at Jefferson School. Discounted, because the timing wasn't right. Maddie Owens sees a strange man bothering her so much that she's reaching for the knife that she has. That is not the janitor, okay? And they brought a picture in of Mr. Stetson, and you can look at the hair. You can decide for yourself if you think that's long. But I don't think there was any confusion of Miss Owens that she was talking to a school official or seeing a school official when she saw that person walking away from the school. Stoy Hodson, Mary Baker, the box. Many years later, they're doing the testimony. Two things are true. Number one, that box may have contained Jennifer Lewis's body, it may not. But it seems to me you can remove a body out of a box that's in a bag and put it on the field. So the fact that there's not a box there at the burn site means nothing. The other thing is that even if the date's not particularly, even if it wasn't that day, if it was the next day or the day after, it could have been the removal of evidence, which would have been the same scene from that abandoned house that was next to their house. We don't have to prove a thing, but all of these things raise a reasonable doubt, more than a reasonable doubt, an incredible doubt. Finally, what they don't have. That's what they think they have, okay? That's the evidence that's presented. So here we go. This is our case against Mr. Liggins. Again, I didn't have to say a word at the beginning. There's more questions, more holes. Where's the 1 gallon gas can? He said he had a 1 gallon gas can. What got gas? Where's the 1 gallon gas can? There's a 2 and a 2.5 over there. Never seized, never one found. Does that Trans Am really run? He wouldn't have needed a gas can if they were borrowing somebody's car. 1301 Vine, the shoe prints. When they went and examined 1301 Vine, Wanda Hughes brought in gave them the tip about it. They found the shoe prints that were in there, but the only comparable they had was Mr. Liggins. Because they didn't think that they should maybe compare that to somebody else. Eddie Zapien says that they took items from him, seized them from his house, seized them from his car. Where are they? If it's true. Not a single piece of physical evidence was removed from the Glen residence other than a bike. No bed sheets. The towels were not removed. I don't care if they're damp or not. No complete forensic search of that residence ever happened, and no complete forensic search of the abandoned house next door, which Freddie Gonzalez confirms was used as an alternative driveway. You know, someplace you can park next door. And yet, out of all the thousands of pieces of evidence that Mr. Bush testified, you remember the first week, I think it was on Friday, maybe it was the second week, it's all a blur right now. Out of the thousands of pieces of evidence that they examined, they could not tie a single one to Mr. Liggins. But what if they had examined Paul, or who his friends were? If they had investigated Paul, maybe, just maybe, any of those unknown DNA samples that they find in the DNA, which they re-examined again in 2014, maybe, just maybe, that would give us a clue as to who committed the crime. And if only they had investigated Paul, maybe, just maybe, they would have had some shoes to match up with those shoe prints of 1301 Vine. If only they'd investigated Paul, any unknown fingerprints, they would have been matched up with Paul's, possibly. They would have been able to determine where he worked if he had access to trash bags. But they picked Stan. You heard the evidence on those trash bags. The trash bags that were found on Miss Lewis's body did not contain titanium. They're not in the same physical makeup as the trash bag that Lieutenant Schaefer miraculously found over at that inn. They were chemically different. They were not the same bags. All right. I'm going to sit down here in a second. I don't have a chance to talk to you again. There's a lot more out there. You all know it. All I'm asking is that you do what every side is asking for, and that's critically examine the evidence. I'm confident that when you do so, each one of those links, and one of them or all of them, there's no proof beyond a reasonable doubt. They are nowhere close to that bar. And then the decision is easy, and the law compels the verdict. And when you can't get over that bar, in this case, they're not close, and the verdict must be not guilty. And that's what we're asking for. So thank you.
Scott County, Iowa attorney Mike Walton rebutted Haubacher's arguments.
Definitely. Okay. All right, Mr. Walton, you may present your rebuttal on behalf of the state.
Thank you, Your Honor. Ladies and gentlemen of the jury, I know you're anxious to get to the jury room and begin your deliberations. You've now spent into your fourth week on this case. Your attention this morning, your attention these past 3 weeks have been admirable and appreciated. It's a complex case, no doubt. And there just are some things that Mr. Hawbaker said that I feel I must respond to. And so we're going to go through some of those again. And shortly you will retire to the jury room. You will deliberate to reach a verdict. But I want to remind you that verdict is to be based on evidence. Evidence that was presented in this courtroom. People who took the stand, swore to tell the truth, were subjected to cross-examination and direct examination. That is evidence. We've heard a lot of kind of speculation about things that may have been or could have been. That's not evidence. The Davenport Police Department and the Rock Island Police Department and the FBI doesn't necessarily get to pick their evidence. They investigate and we present what's found. Now, evidence, and one thing I want to take issue with that Mr. Hawbaker said, and this is very important because he left there, I got the impression from what he was saying is that you have to be convinced of everything that's said from that witness stand beyond a reasonable doubt. That's not the case. That would never be the case. That every single link in some chain has to be solid or the whole thing falls apart. That's not how it works. That's not true. The things that must be proven beyond a reasonable doubt are those 5 elements of murder in the first degree in the marshalling instruction. Those are the things that you must be convinced of beyond a reasonable doubt. Not every single thing said, because that's your job. You evaluate the evidence. You make a determination on which of it is important and which of it isn't, which of it is reliable, and then you make a determination on whether you're convinced of those 5 elements beyond a reasonable doubt, not everything that's said, because we're dealing with human beings, and we're dealing with 28 years ago memory, and that's going to be difficult. So again, your common sense, your experience, you make a determination of what evidence you believe and how to apply it to the law. Now, again, we can go off in a lot of different directions about what could have been done and about scary people walking down 12th Street and about Paul in the neighborhood who's a mean guy or a jerk. 13th Street where an abandoned house and footprints were found. And it goes on and on and on. As an investigation, I guess, could too. But I want you to focus on the evidence. The evidence is the hard path, is the clear path. Speculation or rabbit trails. And what I mean by that is if you've ever been on a walk in the woods and you're on a path, sometimes you're on that solid path and sometimes you see something that goes off this way a little bit. And you might go down that thinking it's a path, but it's not. It's a rabbit trail. It's not the main path. You go off and you go and it's a dead end. And what are you going to do? Are you going to keep going down that rabbit trail? No. You got to go back to the path. You got to get back to the path of evidence and beyond the speculation of wandering around in the woods about it could have been this, it could have been that, if only we had this, if only we had done that. Over 28 years of second guessing, you know, we could have had it much better, but we don't. We have what we have. So we have a lack of forensic evidence in this case. We know why. And I'm not going to show you those pictures of Jennifer again because you've seen them enough. But we know what happened to her body and we know why it happened. She was set on fire with gasoline for a purpose, so that there would be no trace, so that there would be no evidence. And you heard the testimony of Captain Carpenter, years of experience of burned bodies and looking at gasoline pours. And he said specifically where that gasoline was poured. And that was on her vagina, in that area. And then back away from her. To destroy evidence. That's why we don't have forensic evidence. Not because Davenport didn't try. You have the testimony of Dr. Stevens, the same thing. The same thing. That's where those injuries were, and there's a reason for that. To destroy evidence. That's why we don't have that evidence, not from a lack of trying. Same thing with Paul Bush. that seminal fluid, those evidence by high heat, they're destroyed. They're destroyed. And forensic evidence can be destroyed by other means. Forensic evidence, trace evidence can be destroyed by cleaning. Now, can we prove beyond a reasonable doubt that the reason that car was cleaned was to hide forensic evidence? No, we don't have to prove that beyond a reasonable doubt. That is something for you to consider. But when you look at the evidence, it certainly appears that it was cleaned recently. It certainly appears that it was cleaned with an excess of water based on the water, the dampness underneath the seat. You have the testimony of Ronald Sinclair of the shower going for 45 minutes in the morning of the 18th. Again, none of those have to be proven beyond a reasonable doubt. It's your job to put the weight to them that you feel is important. So we have all these other people, okay? And let's talk about that. Because Davenport did talk to these people. And the thing is, at some point during an investigation, you have to give something weight on whether it's valuable or not. So we take Roberta Cadera. Now, at first she says she saw a guy with long hair running away from the scene in tennis shoes. That description over the years grows to other things. But the most important thing about Roberta Cadera's statement from the beginning was she says it was around 9 o'clock. Right around 9 o'clock. We have the testimony of Christina Olson that fire started at 8:16. So the first thing I want to point out is how likely is it that the man that set Jennifer on fire is hanging around for 45 minutes at the fire scene where she's located? Not likely. Not likely at all. The other thing that we know is that Randy Stender, who, yes, has long hair, and you have the exhibit, is running back and forth from that scene at 9 o'clock. The 911 call comes in at 9:06, I believe. And the other thing we know, as the finger is attempted to be pointed at Joe Glenn, is we know Joe Glenn was home at 9 o'clock. Because that's the 911 call. The Rock Island Police Department is at 8:54. Officer Johnson arrives sometime thereafter. We know Joe Glenn is home. It's not Joe Glenn. It's not the murderer. It's not that important. And then we get to Linda Stoy Hodson, who, no, at the time of the arrest, was not interviewed because she didn't come forward for 9 years. So Davenport didn't have any opportunity to interview Linda Stoy Hodson because she didn't tell anybody for 9 years. Even though she knew there was a murder, even though she knew there were trials, she waits 9 years to come forward. And then what a story she has. A weird night, the reddest sunset I've ever seen, nobody on the street. It was like an Alfred Hitchcock movie. And I see this person coming out of a house with 5 people standing around. Now, do you really believe if Joe Glenn was taking a body out, Jennifer's body out of the house, he would do it in front of an audience of 5 people? Hottest day of the year, she says. Over 100 degrees that day. The temperature was a high of 70, an average of 56. She's wrong. It was not that day. She describes the house as blue with some yellow. That's a yellow house. 3 or 4 stairs off the side of the porch is where they came with the box. There's no stairs off the side of that porch. Let's say front, comes off the front. And most telling and most important about Linda Stoy Hodson is if she was not in a box, and if that body was not burned in a box, then I'd say my information is insignificant. Because there's another thing that she says is she learned about this death from a news flash at between 7 and 7:35. Well, Jennifer wasn't even reported missing until about 9 o'clock, some 2 hours later. She didn't see anything on the news at 7:35. It didn't exist. Her information, she is correct, is absolutely insignificant. The news didn't say Jennifer was burned in a box. Jennifer was not burned in a box. You can see the pictures if you wish. There isn't any box around Jennifer. You've heard the testimony of the experts. If she had been burned in a box, you'd see some box there. Anybody who's ever thrown a cardboard box into a campfire knows you're gonna see some burned cardboard somewhere. You also can't get the burns on Jennifer. It wouldn't burn that way, as Captain or Chief Heyman testified. It would have been an oven. It would have burned her completely. Would have burned her hair before the box burned. There would have been a box underneath her on a protected area where her skin didn't burn. Jennifer was not burned in a box. Linda Stoy Hodson is not a credible lead, so even if that had come up in 1990, when she should have brought it forward, if in fact it occurred, it would have gone nowhere. It would be a rabbit trail that at some point you have to stop following. Matty Owens, again, now the Davenport Police Department couldn't do anything with Matty Owens. They couldn't track down this mysterious, scary guy because she didn't come forward. They didn't even know about it. In fact, Linda Stoy Hodson and Matty Owens never went to the police. They never reported this to the police. They went first, 9 years later, to Mr. Liggins' attorneys with these tales. And so 9 years later, Matty decides, nice woman, probably was scared by somebody at some point, but it had nothing to do with Jennifer Lewis. If this individual running away from Jefferson School was involved in Jennifer's death and destruction, where's the gas can? They had to have a gas can to set her on fire. This guy's not carrying a gas can away from the scene. There's not a gas can at the scene. Where's the car? How did he get her there? Why is he walking away? It's not credible. It's a rabbit trail. You can't fault Davenport Police Department for treating this as anything more than some information, and when you look into it, it's not credible and doesn't deserve further follow-up. And why not Joe Glenn? Why wasn't Joe Glenn a suspect? Well, he was a suspect. The problem is Joe Glenn could not have done it because Joe Glenn was home the entire time. We know that because however long it took Sherry Glenn to breastfeed Damien, which goes from 20 minutes, and apparently at one point she said 90, which sounds really excessive to me, but anyway, she said when she came out of that room, that's when they had the discussion about Jennifer, and where is Jennifer? And that's when she started making phone calls. And you have the testimony of Mark Titus that Sherry called at about 7:14 looking for Jennifer, and the phone records prove at 7:14, and you have the exhibit, it's actually Defense Exhibit N. Mark Titus is the one that they called at 7:14, 786-3803. Joe is home at 7 o'clock, and he's home thereafter. Now, how does he get over to Jefferson School with Jennifer's body and burn her if he's home at 7 o'clock when she's first noticed missing? These are the sorts of things that police do. They go down those rabbit trails a little way, but at some point you got to get back on the path of evidence. You can't be just flailing around in the woods out of every boogeyman that may live in the neighborhood. No, you don't have any evidence of this Paul. That's just a fact. You don't. Let's focus on the evidence you do have. Joe was home. That's verified by Sherry. And I suppose you can fault Sherry for not doing exactly what others may have or should have done when they first realized their 9-year-old daughter is missing. I think any of us that have ever been in a situation where even for a second in a store, you lose track of your child, you know the panic that sets in, even for a second. So as that situation develops, as your child, you don't, and at first, what's your first thought? She's down the street. She's at the front. She's got to be somewhere. We can just find her if we just keep looking. Now, maybe you wouldn't go back to Max because you figured, well, she went to Max before 7 o'clock. It's now many minutes later, so obviously she wouldn't still be there. Maybe, what was her thought process? I guess we can fault it all we want. We can say you should have done this, and why didn't you do this? Clearly she's panicked. And so she's leaving, she's coming back and forth, she's making calls, she's probably thinking more and more things. Could be here, could be there. Every time she comes back, Joe's there. And remember, they also have an infant child, newborn practically, within months, with serious medical needs. And Joe's staying there with Damien as Sherry continues to look for Jennifer. The defendant's vehicle, anyway, is at Jefferson. You heard the testimony of Mr. Eston. I believe the testimony was he identified that car. He had several opportunities to look at it. The testimony of Wanda Hughes was not that she saw square headlights, because, yes, at that time, there probably were many cars with square headlights. That's not the point. You've seen the headlights on this car. You've heard the testimony of Wanda Hughes. It was the fact that it was defective, and it gave it a unique pattern as to how the lights were situated. It wasn't just that they were square headlights. It was the strange pattern of how the lights were working. And that's what makes it unique to the defendant's vehicle. That's the identification, and you've seen it. And whether you think that's unique, whether you think that's something that would stand out in your mind, if you had seen that, that's a decision for you to make. But we know Joe Glenn was home. Doris Dorman saw him yelling for Jennifer. Officer Johnston said he was there. Joe Glenn was home. That's what the police figure out. That's what eliminates his suspects. If he couldn't have been over at Jefferson burning Jennifer's body, then that eliminates him as a suspect for the most part. Now, back to Stanley Liggins and the path of evidence. What do the police find out about Stanley Liggins? He left the Glenn house 2 times when Jennifer left. That's important because that's odd. Not that he just ran into her on the street and said, "Hey, how you doing? Hi, Jennifer." That he left, that he went to the Glenn residence, that he's there with adults, that Jennifer leaves, and he says, "I've got things to do, people to see," and leaves. That's a goodbye. That's not, "I'm gonna run down and get a soda or get a 6-pack of beer." That's, "I'll see you, I'm leaving," and he leaves. And where's he seen, as already been pointed out, a couple blocks away from where Jennifer is on her bicycle. He's seen her leave. He leaves right after that. And then they're seen talking, and remember, I believe it was Marianne Watson who was concerned when she saw this car coming down the block and the kids out there playing. It concerned her enough that she kept an eye on it because she was worried about her own children. And that car slows down, it pulls up and beckons. He beckons, that was Diane Pemberton, he beckons Jennifer over, calls her to the car. Jennifer doesn't go up to his car, calls her over. They have a conversation. That's odd, I think, because he was just at her house. I think most of us, if we want to talk to a 9-year-old child, will do it in front of the parents. We don't do it 2 blocks away. And then it gets even stranger in the fact that after that conversation, Jennifer, and again, instead of playing with her friends that she was with, she rides her bicycle home. Is so excited to get home, she crashes into the porch and runs into the house. Now, who comes back? Stanley Liggins. He's already said goodbye. He's talking to Jennifer, she comes back, he comes back. And then, why does she leave again? Because he sends her on an errand to buy gum, and she gets to keep the change from $1. And she's excited about that. And so away she goes. Now, if he had come back to be with the adults, why doesn't he stay? Why doesn't he stay and play foosball, have a beer, whatever the adults are doing? He leaves shortly after she leaves and doesn't say anything. This fades away. It's a setup. That's what got Jennifer away from her house, away from her family, and close to him. And he's seen at Matt's. And again, Davenport Police Department doesn't pick the witnesses to these things. Antonio Holmes says, remember he said, after I talked to Charlotte, and she said, remember that little girl you saw? That's the girl that got murdered. And it's after that that Antonio Holmes comes forward to the police and says, I was there, you know what, I saw her talking to a man. Now, they do a photo lineup with Antonio Holmes. Apparently, no criminal charges pending at that time, no offers at that time. He makes an identification. Stanley Liggins. He thinks about it, he comes back to the next day, and he says, I'm not sure. That's all disclosed, that's all known. There's no secret there. If the Davenport police or the prosecution wanted to enter into some sort of secret deal with Stanley or Antonio Holmes, could have started then, said, you'll just go away. We'll give you a deal, don't worry about it, go away. No, it's disclosed. That's what he said. They can't help that. That's what the witness who identified him the night before comes in and says, I can't be sure. When he's under oath in a court of law, he says he is sure. 3 times now. So the credibility of Antonio Holmes is not up to Stanley Liggins' attorney, it is up to you. And so you evaluate Mr. Holmes, you evaluate whether or not you think that he came in here and perjured himself for some sort of deal 20 years ago, or whether he's telling the truth to the best he can. That is your decision. Again, I didn't pick him. And by extension, Mr. Hawbaker's argument would be that we're in on that too. That I care so much about some sort of conviction that I would enter into perjury with somebody in order to have them testify a certain way. That I would risk my career, that all those police officers, career police officers, would risk their careers, would come up here after retirement, many years after retirement, many of them health concerns and have to bring themselves in here, would do that in this case. That's your decision. That's an issue of credibility regarding Antonio Holmes. You believe him or not. Same goes with Frank Rising. We didn't dress Frank up. You know, Frank came in, Frank is who he is. I didn't pick him. If I had to pick, you know, if I went to the store and could pick witnesses in a murder case, Frank wouldn't, even on discount, probably be purchased, you know? That's who he is. And if he's lying, why such a kind of weak statement? If he's getting some sort of benefit or expected some sort of benefit, he could have done a heck of a lot better. He could have said anything he wanted to. Oh yeah, he confessed to me, he told me the whole thing. No. He says, I saw him on the news, I said, hey, that's you. And he says, I might have done it, but they can't prove it. Sounds to me possibly like somebody who's so confident in the destruction of evidence that they've done, that they're confident that this can't be put together because of lack of forensic evidence. Remember what Frank said? And I asked him, you know, are you an informant? Did you get anything? Remember his response? I hate cops. And that was an honest response. This isn't something Frank does. If Frank is such a bad person, we know he's not really in with the police. And so, again, a certain rough credibility to Frank because he's not, as his own testimony shows, the kind of person who normally is going to involve himself with law enforcement. And I think you need to judge his credibility about why he says he came forward. And he says it's because he has daughters, and this was wrong. That's your decision. And then there's Mr. Ligon's statement. Now again, I guess you can assume that Detective Holden, in those two prior cases where he testified, perjured himself, you can assume that.
Objection, Your Honor. You can't argue that. Belgium, Mr. Holden, can make an argument for that.
Consisting.
You have to come up with some reason of why Detective Holden would come before a jury 2 times and not be honest. But you have also the corroboration of Scott Jensen, FBI, who again was there and agrees with what was said. You make that decision. So 6 o'clock, he agrees, he arrives at the Glens. So again, we've got time similars there. We know it's 6 o'clock before he arrived there. But he denies meeting with Jennifer when they ask him, when they talk about it. Now, why do you suppose that is? Why do you suppose he didn't want the police to know he had met with Jennifer 2 times? Typically, if people deny something or leave something out, it's because they don't want people to know. And there's a reason. After being confronted, he admits that in fact he did speak to Jennifer. So again, that other evidence is corroborated. He admits that he sent Jennifer to get gum for $1, and he admits to leaving, which is another odd thing. Why would you send a little girl to the store to get you gum that you made a big production of, that you need gum, and you send her to the store, and you leave within 10, 15 minutes before she gets back with your gum? Doesn't make sense, unless you're going to meet her at Max. He said he had to get home to the hillside by 7 o'clock because he wanted to call his sister. From the testimony of his sister in the phone records, we know that never happened, even though he said he called. At 7:45, he calls the Glen residence to see if Jennifer had returned with his gum. Well, that's kind of odd too, isn't it? I mean, you wait that long, you leave before she gets back, and now you're calling to see, hey, did she come back with my gum yet? And he said he's at a bar to the Glens when he called them. Never happened. He didn't tell the police he ever went to the bar. The Glens already were suspicious because there was no bar noise. Why do you suppose he did that? Because he wants to know what's going on back at the Glen house. He wants to know, do they know Jennifer's missing? Do they know I was with her? Is there any connection to me? What's going on there? And then, 8:45, he drives back to the Glens house, and that's the time frame when Armand McCauley sees him driving erratically. And he goes back to the Glens house, finds out Jennifer's missing, says, you better call 911, chuckles and leaves. Again, you're not gonna help look for the little girl. You're not gonna drive around and you've got a car. You're not gonna drive around and help look for this little girl. Can you imagine what Sherry was like at that point? Can you imagine what Joe was like at that point? You're not gonna help out. As far as the timing goes, you have the records of how long it took to get from the hillside to Jefferson School. I believe it's 13 minutes. And Max, those trips, there's time. And how long it takes to kill a little girl and rape her, I don't know. Not long. Not long. But he had that time. He left the Glens until he comes back at 8:45. He says he went to Brenda's house about 10. He mentions the TV shows, I believe it was Arsenio that he watched. Stayed there all night. But we know, in fact, he didn't go to Brenda's at 10. He didn't watch those shows there. He didn't show up till nearly 12. And she remembers that because he called and said, can I bring you anything? And she said, cigarettes. And that was before 10 o'clock. He doesn't show up till midnight. Now, Brenda Adams did not say he stayed the night. What she says is the car was there at 2, but my recollection of her testimony was she had no idea after that. They were not sleeping in the same room. She was sleeping in separate rooms, and she says she had no idea where he went after that. But he has a sighting at the hillside at 3 a.m. by Thomas Perkins, who gets up to get a soda and sees Stanley Liggins, sees the vehicle, arrive back at 3 a.m. Again, why? Why do you do that? First of all, why do you go back at 3? Second of all, why do you mislead the police about that information? And you have the testimony of Rodney Sinclair, shower running excessively, 45 minutes on and off at about 4 in the morning. And again, not all of these factors do you have to agree on beyond a reasonable doubt. This is evidence. You have to agree on the elements of crime beyond a reasonable doubt, not every single thing that was said from the witness stand. Donna Atkins said specifically that that car was parked in front of her apartment at the Hillside Apartments. Again, that's what's odd about it, because he lived in a Hillside hotel across the other way. Again, why? Why are you parking at your own apartment? Why are you parking across the other way? And the only reason she got so close to that is because she's trying to move her boyfriend out. Now, she never said her boyfriend was there when she was moving him out. She said she was moving her boyfriend out, who had been put into, I believe, an alcohol rehab, is what she said. She testified that it was the day, 2 days before she saw the car on the news. That makes it the 17th. The car was not on the news until Wednesday, when they towed it from there. So it was the 17th. That's been established that she smelled gas and saw a gas can in that car. Again, that's odd. That's why it stands out, because it's unusual. And Brenda Adams testified she went to the car at 2 o'clock to get something out of the ashtray, sat in the car with the door open, grabbed something, got back out. She didn't notice smelling gas at that time. She did the next day when she's driving the car notice a distinct odor of gas. Sherry Glenn, all these years later, has no reason to protect Joe Glenn. She hasn't seen him for many years. She says he was there at the house. If you stay on a solid path of the evidence that's been introduced, that path leads to Stanley Liggins as Jennifer Lewis's murderer on September 17th of 1990. Stay on the path, follow the evidence that's in trial. And when you do that, you will find that the only true, fair, and just verdict in this case is a verdict of murder in the first degree. Thank you.
Hey, this is Steve from Great Lakes True Crime. We tell stories from Ohio and the rest of the Great Lakes region, including the Canadian side. So give a listen on your podcast app and follow us on Facebook. Just search for Great Lakes True Crime.